Good morning, all. Distinguished speakers and dear students. On behalf of St. John Institute of Pharmacy and Research, I, Shreyas Masalkar, second year B.Pharm, extends a warm welcome to each one of you at Impact Lecture Series by Institution Innovation Council. Institution Innovation Council, established at St. John Institute of Pharmacy and Research, helps in planning, channelizing, and organizing round-the-year activities in the areas of innovation, entrepreneurship, and IPR to sensitize and motivate students and faculties to pursue innovation and startup during their academics. As a part of this, today we are conducting impact lecture sessions at our institute, which is one of the approach under the IIC program to generate awareness on innovation, IPR and startup with funding assistance from Ministry of Education, MIC and AICTE. The impact lecture sessions will not only be a streamlined campus innovation and startup ecosystem, but also help in establishing strong connection with ecosystem enablers at regional and national level, and our students and faculty members about innovation ecosystem in their surrounding and at national level. As we commence the session, may I request everyone to kindly stand and join in our campus prayer, the Universal Prayer for Peace. Thank you, everyone. I now call upon Dr. Savita Tauro, Deputy Campus Director and Principal, St. John Institute of Pharmacy and Research, to give an overview of today's program.
A very good morning to all of you. Our esteemed guest for today, Mr. Ajendu Soni, who is the head IPR formulations at Indoco Remedies. We will also have our next two speakers joining us soon, faculty members and my dear students. This is a different kind of an event where we are having sessions conducted for students to learn more about how you would go about doing your own startup, your own idea, because two important things when you look at maybe innovating and doing something on your own is knowing about what is already available in the field, what others are doing, so that you do not do something which is repetitive, and that is why you need to have the knowledge of IPR, that is intellectual property rights, and novelty and to look at different things which can give you fantastic careers. While I'm sure all of you may be dreaming of getting a nice cozy job, and today most of the students look at careers in pharmacovigilance or maybe something which is more related to the IT sector where you're only doing data management. But I think there is a lot more scope in the core areas of the pharmaceutical industry. And that is where your innovative ideas, your, I would say, the creativity that you have will give you a better edge over the others. We have today speakers with us who will give you definitely, I think, a wonderful overview on how, as a student, when you are entering into this new field, you should look at data which is going to help you decide how you will use your own ideas forward. So, the Institution's Innovation Council, which is a kind of a cell which has been constituted under the Ministry of Education and which is also supported by the MHRD, has insisted that these kind of activities should be conducted in every college so that we are able to stimulate the thinking in students to maybe do something differently. And I think that is what is very much essential for you. The road that is walked by so many I would say students, so many experts ahead of you should give you an idea of where you can make a difference to the current scenario of the pharmaceutical industry in our country. So much has been spoken about, the Make in India, the startup events. There is a lot of funding that is also being provided by the government. So I think it is you students who should start thinking in this area and start maybe becoming more or creating employment to a larger extent rather than only looking out to the employees in an organization. So I think our subject experts of the day will definitely enlighten you much more, and I'm sure even our faculty would be, the senior faculty also are very interested in learning about this because that is also how it gives you an idea to look into areas for research. IPR is one of the most common, base I think that is required for any one of us to even look at any new thing that we would want to venture in. So I wish that each and every student really concentrates and takes back a good, I would say, learning from today's sessions because this is what is going to help you in your industry, in your industrial career further. And I'm very grateful to both the speakers who will be here today and who have willingly come here in spite of, I know that they have very busy schedules, but to make their time available for you, that itself is something which is very appreciable, and therefore students see that you make the best use of their expertise. I'm sure they will be very happy to take questions from you and give you the knowledge that you would want to really learn from at this, I would say, the very preliminary stage that you are in. So wishing you a good interaction during the session, and I hope that all of you will go back to good learning today. Thank you very much.
Thank you, madam. Flowers are a symbol of salutation and admiration. We would like to acknowledge our today's speaker and welcome them with floral bouquet. I request Dr. Savita Tauro to present a bouquet to Mr. Ajay Suman. We shall now begin with the first session of today's program. I now request Mr. Devendra Palwalkar, second year M.Pharm Quality Assurance, to introduce our speaker, Mr. J. Suman.
Good morning to one and all. Mr. Ajay Suhani is an accomplished IP expert currently working as a head intellectual property rights, formulation and in-house counsel at Indigo Remedies Limited. He has done Masters in Pharmacognosy and Phytochemistry from Principal K.M. Kundani College of Pharmacy and is also a registered Indian patent agent. He brings with him close to 18 years of rich experience from various giants in pharmaceutics industry. He is not only informed about intellectual property but is also well versed with the drug regulatory procedures. In his current role, he is responsible for building IP strategy for various products of the company, providing IP clearance, executing IP agreements, managing patent portfolio, drafting and prosecuting patent applications, preparing legal opinion on patentability, patent infringement, FTO analysis and validity issues, and recommending effectively managing e-discovery process for para 4 products, suggesting new molecules for development to the portfolio team. He is also well versed with the art and skill of IP prosecution, litigation, licensing settlements, and subsequent procedures thereof. He has been invited as a speaker and a panelist for discussion in various IP forums. Prior to joining Indoco, he was associated with Encube, Cipla, Ajanta Pharma, Unichem Laboratories Limited, JB Chemicals and Pharmaceuticals Limited, and Dr. Reddy's Laboratory. We welcome you, sir, and request you to take over the session.
Thanks for the lovely introduction, and nice to see all of you enthusiastically participating in this. Before we start, I want to make this as an interactive session because intellectual property rights, if you see, it's a scale word. It is a part of legal, a part of technical. So before we actually go into intellectual property right, how many of you know what is IPR? I don't need a legal definitions. Your thoughts. When you say IPR, what is it that you think of? No answers? You can use this.
Own ideas. Own ideas.
Own ideas. Any other answer?
Intellectual property is innovation of mind, which is an intellectual property rights is innovation of his mind. Innovation of mind is protected by some legal rights.
Legal rights given to an individual for their ideas or innovation.
Right, correct. So it is a creation of mind. Right? So when you say creation of mind, it can be ability to think, to create something. It could be work of art. When I say work of art, it's usually a copyright. So you draw a painting, however bad that could be, it is still your copyright. You can sell it as an abstract painting to any, and you have rights on it. To solve a problem, when we say to solve a problem, it usually goes into a part of patent system where companies faced with some problem, they want to come out of those problems. It could be a drug stability, it could be solubility issues, it could be some other hurdles coming because of somebody has a patent on something. And then it has to be novel and unconventional approach. If you are copying somebody else's poem and simply changing few words, it is not your intellectual property rights. I mean, a translation of a poem, you may have a translation rights, but first question is, to do a translation, do you have a permission? When we all use, I've done my research, I've used a lot of articles. and we assume that by using those articles, doing a work, reproducing it, we are free to do that. In IPR, it is not the way. If you have to use somebody else's work, ideally you are required to take a permission. Have you heard of a famous case of Delhi University? There was a case on xeroxing in India. Pure photocopy, right? For the exams. Now, some book publishers who are publishing the books which are very costly, what Delhi University guys did, they were very simple. Issued it from the library, went outside the campus, xeroxed it. So they were all sued for the infringement of their copyright. Fortunately, government or the IPR in India is such that we are not going to be kill the innovation at the same time we want the masses to learn. So photocopying for personal use was found okay, as long as that Xerox guy was not selling the book per se. So if I go with the book and I do a photocopy of entire book, my own personal use, it is allowed. But if I make copies and start selling it, it is the infringement of that publisher's right. So there is a very clean line on what you can do in IPR and what you cannot. We will go through that slowly. So the question, the intellectual property right is a tangible or intangible right. So before I go into that, are you aware of what is tangible rights and what is intangible rights in a property? So tangible is something which can be measured, and intangible is something that cannot be measured in terms of economic value. So now the IPR in general, what is your say? It's a tangible right or intangible right? It is tangible right because every IP can be economically valued. You have a patent, there is a valuation for a patent. If you have a piece of art which is copyright, there is a valuation. If you have a trademark, there is a valuation. Except for trade secret, everything can be valued. So we will just go in short on this slide on different types of IPR, and then I'll go through each one of them in very brief. Though my introduction says head of IPR formulation, I am responsible mainly for patents. In my past, I was responsible for patents and trademark. Usually, the copyright issues do not arise when it comes to pharma industries. And even if they arise, they are handled by the core legal team. Because copyright per se is entirely a legal requirement. Patent is the only field where there is a technical input required. Otherwise, all other forms or most of these IPR are required to be having a legal knowledge. So, design. Does anybody know what is design? There's a slide on it, but that slide is a technical slide. You all have seen the Bisleri bottle, you all have seen the Coke bottles. The appearance, any external appearance is basically a design. So even your pen which you are using every day, the appearance of that pen is basically a design. Now, why you need a design protections? Why you need a design protection? So basically, just think of somebody is creating a shape of an inhaler, right? Now, how is going to protect that inhaler shape? It's a unique inhaler. Or somebody comes up with some deodorant which is metered deodorant. We don't have a metered deodorant, right? You spray it will come as a one spray, two spray, three spray. So now that invention can be protected either by design, how it looks like, or by patenting. But when I say patenting, you cannot patent a deodorant bottle. You can only patent a specific component which makes it a metered deodorant bottle. So let's go through this. So design is basically an industrial design, industrial layouts which are given the legal rights. It's a handcraft, and in India it is protected by a Design Act 2004 with the amendment rules in 2001. The protection for design is 14 years. So there is a limit for protecting your IP. Some of the IPs are perpetual, whereas some IP have to be given up after a particular time. So after 14 years, anybody can copy that particular design. So there are also international treaties which cover the design. So you can see I just use a graphic which is a model of cycle. Now, probably when I want to go and exhibit into something, I'm coming up with some innovative model. How will I tell my customer? Is by way of such kind of designing. Now, if such design is not protected, then anybody else can copy and probably start marketing it. So that is where the design protection is essential. Copyright. I think everybody is aware of copyright. Whatever you write, whatever you express, whatever you draw is your copyright. So this presentation is my copyright. You cannot use this presentation anywhere else without my permission. So if your college has a copy of this presentation and if they want to circulate it, basically they will ask permission from you. Can we circulate? If they don't, then that's a copyright violation. So copyright is basically nothing but it's an expression in terms of some written language. Copyright Act in India provides a protection of lifelong plus 70 years. In Europe, it is 50 years. When I say lifelong, if this particular presentation is my copyright, till I am here alive, it is my copyright. Post that, it is protected for 70 years. Now, for this presentation, that is not required, so forget about that. If somebody has written a song, Bollywood song, Hollywood song, somebody has written some story, now all these, they will have a copyright protections. Now that protection will run till their life and post that because they have done something, they have created that IP. Their family or their legal heir should also be entitled to get the benefit out of it. So it will continue for 50 or 70 years. In India and US it is 70 years, in Europe it is 50 years. Most of the countries have this 50-70 period. So for example, I think some football, Brazilian football, there was a Coca-Cola ad which had a song. Now that's a copyright created. Nobody can use that song. So even when the Coca-Cola has to run it, he has to have a permission for the copyright. Now copyright is entirely legal matter and it is very complex. Just think of a Bollywood film that you might have seen very recently. There are multiple copyrights involved. There's a copyright on writing of the story. There's a copyright on the lyrics. There's a copyright on the song written. There's a copyright on the tune which is given to song. Then there's a copyright of a singer, the song. There's a copyright of an actor who has done an actor. So many people copy the famous fire dialogue from Pushpa. It's the copyright which is created in that movie. Now we use it. But if somebody wants to use it professionally, they have to approach to the user. Now in this case, it is the cinematographic industry. They have their own forum, to which all the copyrights are registered. So whenever you see any awards happening, people are performing on somebody else's job. How can they do that? I mean, in our local societies, we do it even without permission. Right? It is allowed. Officially, it is not allowed. Somebody can come and stop it. But we don't take that much seriously on the copyright infringement because it is fun intended. We know that it was not a professional program. It's just a local performance given in some society, in a college or something. So the permission is not required. But the same performance, if you have to do it professionally, you'll have to go and approach a cinematographic industry, get a license from them, and then you can do it. So remember, initially we used to have a lot of MP3 sites, they were giving us all the free songs. Now suddenly that has gone down. There are very few sites which are given, and they will also give you a free song, say for 1 month or something, and they will say, okay, now if you want to enjoy listening to this, please subscribe. The reason is to provide you those songs that particular company is paying to the industry. So they need in return from the users. They cannot simply keep on paying from their pocket. Geographical indication. Can someone tell me what is geographical indication? From from the name you can guess. Any answer, it can be wrong. There's nothing wrong in writing IP. So it is basically a type of IP which arises because of the environment in which the product is either procured, manufactured, or naturally occurring. So we all say Assam tea, Darjeeling tea. Now that, what does that indicate? It indicates it is a tea which is probably cultivated, and packed into Assam. When we say Darjeeling, it is the one which is cultivated in the hills of Darjeeling. We say Kolhapuri chappal, and all that stuff. So these all are GIs. Now in order for a GI cannot be owned by a single person. I cannot own a GI because anyone who resides along with me will also produce a similar kind of product and he will have the same qualities. So even he is entitled to claim that as a GI. So usually GI is granted as a collective mark. It's also, before the GI Act, it was a part of trademark under collective marks. So champagne, which is a countryside in France, so anyone who grows grapes there and ferment it will prepare a champagne. Now any person who does that has a right to use that word champagne. But if someone in Sula is doing that, they cannot use the word champagne. So if you see Sula uses a word which is sparkling wine. I think you might have not tried that, forget about it. But if you come across some commercials on alcoholic beverages, they cannot use champagne. Even on a chappal, we have a leather chappal scripted. You cannot use a word saying Kolhapuri chappal if that chappal is not manufactured in Kolhapur. It has to be taken from an animal skin which is tanned, processed, and done everything within the Kolhapur district, and then a chappal has to be prepared. Now chappal also has to be prepared within Kolhapur. So if you get a skin or a raw material for chappal and make it in Mumbai, in Naravi and say it is Kolhapur chappal, you are actually infringing the GI because it is not made into Kolhapur. The process of preparation itself will have an environmental impact, because of which you get that particular sound when you walk using that chappal, which you will not get when you use a chappal prepared in Kolkata. Because Kolkata is also one of the major labour markets. Semiconductors. Now, semiconductors in India per se are not patented. So, Indian Patent Act, which I'll come to it later, has a particular section which says what all cannot be patented. So, what happens to an IT industry? What happens to all our computers? They all work on semiconductors. The Intel processor is nothing but a series of semiconductors put together to give a particular performance. So, you have i3, i5, i7, and all that stuff. So, if they are not protected, the companies will not want to invest money in India. In US, semiconductors can be patented, but US also has a separate Semiconductor Act under which they are protected. Similarly, we also took a Semiconductor Act which is basically on a designing of a semiconductor. So, have by any chance in the older era, have you seen before the LEDs came into our houses, the TV used to be this size big. So if you open by any chance the cover, you will see all the circuit of the TV. Now that circuit is nothing but protected under this Semiconductor Act. So the design of circuit, where which component is put, can be protected under semiconductor. It is difficult to protect it under patent because if I have to protect, say, Intel chip under patent, then it is very complex. Patent requires you to disclose each and everything of that component. It's not feasible. Even with the AI, it is difficult to mention each and every component in that small chip, which is used in our laptops, in our phones, and everything. So what can we do? We still want to give a protection. So we will protect the designing of that chip, the internal circuits, how the semiconductors are placed, how the other electrodes are placed, where the connections are made, and all that circuit diagram is protected by a semiconductor. Plant variety. Now, this was introduced very recently. Basic reason was you heard of Monsanto. They had a BT cotton. Now they made a genetic variation in the BT cotton and supplied it to Indian farmers. The specificity of that genetic modification was you cannot recultivate that crop. So you have a crop, you use the crop, but if you use the seeds of that crop for the further cultivation, it cannot be done because it was genetically modified not to regenerate, not to regrow. And that had a huge impact in India. We did not allow that. Monsanto was also had a huge impact in Europe. So in Europe, their patents were found, so they have patented this technology. The patents were found invalid on ethical issues, that you are doing something unethical. So India introduced the Farmers' Rights and Plant Varieties Act. Now the purpose of this act is a twofold. One is it wants to protect the flora and fauna of India. We have many traditional medicinal plants, we want to protect them, right? We do not want somebody to just simply go into some forest, take up a plant and start cultivating it. Because then that flora and fauna could be devastated. We don't want some Himalayan plant to come into Sahyadri and start over. Because then all the flora and fauna Sahyadri will get destroyed. So in order to protect that, the Plant Varieties Act of this particular part came into picture, wherein you are not allowed to cultivate any wild variety. Even wild, so somebody sees some wildflower, very beautiful, I want to have that. You can have it for your personal use, that's fine. But if you want to cultivate it, it is prohibited in India. We do not want the wildly grown flowers to come into our market and destroy the habitat of the actual flowers. If it is medicinal use, yes, you can apply with the government with a permission that this is a medicinal use plant found in XYZ forest and we would like to cultivate that for the purpose of medication. Now that will be allowed in a limited area of a land which you will demarcate for the cultivation. But you cannot go beyond that and it is highly controlled. The farmers' right in this act allows farmers to keep a part of their crop for the resowing the next cultivation. So say for example, like I said, I am using a BT cotton. I got a crop, I harvested it. I want to keep some of that BT cotton seeds for the replantation. I don't want to purchase it. Now, if this act is not there, then Monsanto or some others can come up with certain varieties which simply will not allow you to regenerate. Or they may come up with some varieties where hybriding of the plants is not possible. We see we get roses in many colors. Most of them are hybrid onto something else, and the nourishment from that plants gives the color of a rose. There are, if you go to Kashmir, there is a rose garden. There are many rose colors. They are not naturally there. They were cultivated initially, and now they are in plant. So that all is protected in the Farmers Protection Act. Now this is required because India is still majorly an agricultural industry. Right? 70% of population still is doing agriculture. So we want to protect that. Now this act is not there in US, and US is really had struggled in the past to deal with such kind of genetically modified seeds which will not regerminate, or they are prone to a particular insect. So if I have to make a business, I can do it very smart way. An ethical part of my business is I create a plant which is probably prone to some kind of infection which is prevalence there. And then I will use some insecticide which will help you prevent that infection. Right? Now I am earning money from both sides. US had this problem. So US passed presidential orders. They could not enact it, but there is a presidential order which says that you cannot do such kind of unethical business. Because I think US also has a large farmlands. Trade secret. What is a famous trade secret that everybody knows of? Right, Coca-Cola. So Coca-Cola has in a museum in US displayed a formula of their product, but nobody has been able to replicate that formula till date to get exact test of Coca-Cola. If if you compare Pepsi, Thums Up, Coca-Cola, or any other Coca-Cola company, the taste of all 4 or 5 of these are very different. It's because every of these ingredients has some trade secret, which is kept very close. Even in case of McDonald's and KFC, the patties that you get, they are kind of a trade secret. So they supply patty to franchises. They never disclose how the patties is prepared. You know, every morning a franchisee will come. A pickup truck will come to a franchisee. They will give a raw patties and everything, which you just have to fry and serve. But they will never ever disclose how that patty is prepared. So in Coca-Cola, there are only 2 or 3 people who are actually allowed to understand the trade secret. One is the owner of the company. Another one is the one who actually prepares the concentration of Coca-Cola. Even in India, Coca-Cola plant that we have, we do not know the trade secret. Concentrated formula is imported from US and then it is diluted to make Coca-Cola that we get in India. So even Indian, nobody is aware of how that Coca-Cola concentrate is prepared. So that concentrate is a trade secret. So why you need a trade secret? If you see the IPR, this is one branch where you are saying don't disclose anything, don't put anything on paper. Right? Everywhere else it is the expression. You have to express in some way or the other. In copyright, you express your thoughts on a piece of paper or you record it. In patent, you disclose it officially. In trademark also, you make an application, you write C or if it is registered on the right R, if it is not registered, you write PM. But it isn't why then you need a trade secret, and why trade secret is still a part of IPR. There are no laws which governs the trade secret. Trade secret usually falls under common civil laws. If there is a breach of any secret, it is usually taken care of by the Contract Act of those particular countries. So if there is a breach of trade secret in India, it will be dealt with the Contract Act of India and the Indian Penal Code and Indian Civil and Criminal Code. So in India, a breach of trade secret is also criminal penalty. Mostly IPRs do not carry criminal penalty unless it is very much a repetitive offences. If you are a first-time offender, you are usually given a penalty in terms of some money. But if you become a repeat offender, that's when the jail term becomes more imminent. Every IP Act in India has the clause of fine or a jail. But if you see the court ruling, the courts will shy away from jailing you just because you are a first time offender. But if you are a repeat offender, then a judge will take a serious note of it and he will not shy away from giving you imprisonment. Now again, imprisonment in India is not very much robust. Maximum imprisonment you get is 3 years. So that's nothing. But a law can change anytime. The way the government is pushing the innovations in India, last year we did the highest number of patent applications filed across the globe was in India. So the way government is pushing it, there is possibility that these laws will change and a severe punishment will be brought. So the trademark. So trademark basically is nothing but a mark which identifies the goods sold by one particular party. So if you say McDonald's, so M&D, which is their trademark. Now, whenever somebody sees that M anywhere on the highway, you immediately recognize, oh, this is a McD, let's stop, have a burger. So that's how the trademark works. They identify the good which they are selling. If somebody goes into say a phone and someone at the back of the phone has this Apple mark, everybody will recognize that phone is Apple. Now forget about whether it is Apple 15 Pro, 14 Pro, 7, 6, but it is an Apple. So that's how the trademarks are associated, and they are very important in a trade of commerce. When you say Coca-Cola or Pepsi, you have some image attached to it. When you say in a brand's names, Nike, you have some image. When you talk about Nike, you know the shoes are going to be comfortable, there will be running shoes, very lightweight. So you have some picture of that particular service which they are giving. When you say a chain of restaurant Rajdhani, you know it's going to be a thali, they will have X number of sweets, Y number of starters. You already have imagined that. Now that's something which is done by Redma. It is a power which allows for companies to do a business. So if you see on the right, right hand top corner, there is a Indogo written everywhere. That's the trademark of company. How will I identify what product I am selling? I just have to look at this particular mark and I know it is coming from my company, Indogo Empress. So every company who is in a business will have a trademark. So the question, do I have to register a trademark? It is not mandatory to register a trademark. Copyright and trademark are not required to be registered. Once you have it, you have it. It is yours. But it is advantageous to always register a trademark because of the protection it offers in terms of law. So if you have a non-registered trademark, you cannot stop somebody else directly from selling a similar kind of product. So say for example, there is a famous brand which is Bata. And now I'm coming up with a brand which says Tava. Phonetically similar, confusing, but if Bata is not registered as a trademark in India, it cannot simply go and stop the Tava from entering into a market. It has to go for something called as a passing of action. Now, passing of action is something where you have to first go to court, tell the court that this is the infringing rule, it is creating a damage to my products, XYZ. Court will pass an order. The order is not stopping Tava from marketing. The order is to the police to raid that particular premises and really see whether that Tava is similar to Bata. So that's the passing law. But if your mark is registered, you will simply go and file an infringement suit saying that this particular product is similar and it should be thrown out of the market. If prima facie you make a case that yes, the product are similar, there will be a confusion, then the other party will be asked to stop from marketing till the case is resolved. So that is the advantage with the trademark registration offers, but it is not mandatory to register the mark. So if your mark is registered, only then you can use the word R into a circle because it indicates that a mark is registered. If it is not registered, then you have to write a word called TN. The TN simply indicates that you are claiming a trademark or you are claiming that this particular mark is associated with the kind of service that I am giving. But it also gives me an opportunity that it is not registered. So maybe I can still be in the market, earn with works and then more. The damages earned in a registered mark is more than damages earned to a non-registered mark. Because in non-registered mark, you cannot really claim a damage. You can simply, if through a passing law, parties ask not to market, that's it. There is no claim for damages. But if my mark is registered, I can always claim a business loss. But because this particular product was also in the market, it created very bad reputation of my brands, my products, or my services. And I incurred a loss of say XYZ crores, and that can be granted by courts and the other party has to pay that. Now comes the patent. So I have written a legal language of a patent which says a protection given to patentee for an invention for a limited time, or a limited term by the government for disclosing the invention. Any layman definition for this? This is a legal definition by the Patent Acts. In simple terms, you disclose your innovation or your innovative idea to the government, and against that disclosure, government will grant you an exclusivity that nobody else will be able to use that idea, but for a limited period of time. It cannot be perpetual. Do we have any international patent granted? When I say international, it is one patent which is applicable to all the countries. Those who believe it is yes, they can raise their hands. So no international patent is granted. So what is WO something? WO is World Organization. So if I have some numbers which says WO 2009 123, does that mean I have an international patent which can be enforced across the globe or not? I need an honest answer. If you don't know, you can raise your hands and you don't know. So now you have to answer my question. The patents are territorial rights or not? Yes, patents are territorial. So there is nothing called as a concept of international patent. WO number which I gave is simply a means of filing your patent application across the globe. There is a lot of misconcept which is being also spread into patent fraternity that you can go on Google and you can say, do some searches. You will find some website which claims that they will grant you an international patent. There is no such term called international patent. When they say international patent, they have to specify in which territory. So India will grant patent only for Indian territory. US will grant for US territory. EP, which is European Union, will grant only for a territory of European Union. And Great Britain is now out of that union. So your patent has to be validated in Great Britain if you want a protection in Great Britain. Initially, when Great Britain was not, so we had a Brexit, so we then had a Brexit. European Union patents, which was EP something, was also validated automatically in UK. So you can enforce them. But with Brexit, now UK does not accept the patent granted in Europe. You have to have the patent filed in UK. It will be the same patent and it will be independently examined and granted. So all the patents has to be examined by the sovereign laws because Patent Act is not common everywhere. There are certain changes in that. We see that in the next slide. So what is the usual term of a patent? If a patent is granted in any territory, what is the term? For how many years it is granted? Any guess? Yes, it is 20 years. There are some exceptions. Certain countries allows patent term to be extended, like say in US, in Europe. India does not have any patent linkage with the regulatory approvals, and there is no patent term extensions. So if you lose your patent term because you were late into examination and you lost 3 years, you lost 3 years. There is no compensation for that. So typically, these are the 3 pillars for the patents. Your idea should be novel, it should be inventive, and industrial applicability. Industrial applicability is assumed when you file any patent application. Examiner will not raise an objection on industrial applicability. It is assumed that if a company is filing a patent, it can be scaled on an industrial level. Or even if an institute is filing, it can be scaled to a commercial level. That's an assumption. You will not see any examiner citing an objection on industrial applicability. It is assumed it is there. But it is the pillar that it should be scalable. Now when I say novelty, it should be new. When I say new, it should not again be a discovery. Something which is already there and you only discover is not patentable now. So initially, if somebody discovered X-ray, they could get a patent because patent law was not the law. Now if you come across with a particular gene and you say that okay, this particular gene is responsible for this particular disease, you cannot patent that gene. That gene existed. You simply discover. But what you can patent probably is how that gene can be rectified to go out of that disease, or a method of detection of a gene for that particular disease. Again, there are cases in US where method of detection per se are not patentable. There was a concept in my times when I was studying that anything under sun is patentable in US. And that concept has grown large. Even US taking note that not everything is patentable. You cannot patent genes, you cannot simply patent method of treatment, which is simply you are following some study steps, but it is not really a human intervention. So you are taking a blood sample, you are analyzing it, and then basis a level of something you are determining a dose atmosphere. Now that kind of patents are not patentable even in use, because there is no human intervention required. It is not a novel. The metabolite for that particular marker was already there in the body. All you did was isolated it using analytical method, estimated it, and basis that estimation, you determine that okay, now I need to adjust the dose to XYZ. Now that is merely acting on what you discover. So discovery is not patentable. In India, we have section 3 and section 4, which clear-cut mentions of what is not patentable. And probably Indian Patent Act is the only act which is very clear on what will not be granted in patent. It is not that Europe and US grants everything. Even in US, there are many limitations that certain things cannot be granted, but those limitations have come up because of the litigations that happen in the district courts and federal circuit and supreme courts, not in the US Patent Act. Similarly, in European Patent Act, there are certain articles like Article 54, 56 which do talk a bit about what cannot be patented, but again they are not explicit. So it is up to patent office and the court system to decide whether this can be patented or not. It's India who specifically says if you fall into this category, please don't apply for the patent. We are not going to do that. Having said that, we talk a lot of section 3D for pharmaceuticals and section 3E. 3E is overly cited for compositions. It simply says a mixture or admixture of a known substance which behave individually to give you a result. So in formulation industry like us, section 3 is very commonly cited. That your composition is nothing but you have a wetting agent, you have a disintegrant, you have a bulking agent, you have a drug. They act independently to give their results. That's section 3E of section. Now you have to overcome that by showing the synergy that if I have a bulking agent along with the drug, it's not just the bulking agent and drug which makes my composition. I also need to have a wetting agent. And the property of wetting agent changes when I have it in the combination to give me a dosage form which is stable and bioavailable. Again, section 3B objection is raised. It says about known form of a new form of a known substance, new use of a known substance is not patentable. Now this is done specifically to ensure and protect the generic pharma industry. You do not want patent to get extended because somebody files a molecule patent on day 1, then 2 years down the line he files a polymorph patent, polymorph A, then another 2 years down the line he files polymorph B, and now that particular drug is extended unnecessary. We don't want it. But having said that, it doesn't mean we do not grant the polymorph patent. If you can show clinically your polymorph is better than a base molecule, you can get a patent. Again, there is a loophole in this section. It is a known substance, right? So what if I have a polymorph application filed before my drug application is published? I can still get a patent on that polymorph because it is not a known substance under the section 3. And majority of time when a pharma brands are now using this particular strategy because when they are filing their molecule patent, they usually have a lot of data. They also know what polymorph is going to work, what polymorph is not. So they can always protect at least one polymorph. And that is the trend which we are slowly seeing in pharma, that they are trying to push polymorph application also within that molecular time period so that it does not fall under 3. There is a risk involved again because you are not really sure whether that particular form is really active or not. It may come up that during extensive research some other form is active, but in that case anyway it is a known form or a new form of a known substance, so difficult to prove therapeutic efficacy. Therapeutic efficacy can be proven only by animal study or human study. Initially, before playback case in Supreme Court, we all in the industry tried to prove efficacy. because it was not therapeutic efficacy. By showing that my composition is stable, we have a stability data, we have some dissolution data, do some comparative with some other available drug in the market, and show ours is better. That is not acceptable. So now if you want to have your product patented, especially under 3D, you have to show a therapeutic efficacy, which is nothing but some sort of clinical trial. It could be animal trial and it could be human trial. Now the issue here is India does not allow any declarations to support your filing. So that means if I have a protocol for a clinical trial, whether that will suffice the section 3D obsession or not is a murky word. Because my protocol will not have a data to prove that whatever is intended in the protocol is actually happening. In US, you can do that by way of declaration. So inventor can file a declaration saying that look, I have this particular protocol in my application. Now these are the results, and hence prove that my particular composition is better and should be granted a patent. You cannot do that in India. India does not allow any way of declarations to be done. During examination, you may try to convince an examiner, but it's really difficult. And if somebody has granted that way a patent, again it is open for post-grant opposition or revocations into courts because law does not allow it. I'm just giving you an overview about the different laws. You can see Indian law and European law is more similar. Simple reason when European Union was formed, they took a lead from UK Patent Act, and we were ruled by British. So our Indian Act has always come from the UK Patent Act. So in US before 2016, the concept of first to file was not there. It was first to invent. In 2016, they enacted the act called American Invents Act, and they changed it to make it to first to file, to make it in sync with all the countries. Patentability requirements are almost same. They are given a different name. Like in India, we have inventive state novelty. In US, they are codified as a 102, 103, 101, and then 112, which is legal distribution requirement. In Europe, there is an Article 50. Now, when I just mentioned that India does not grant extension, US do grant some extension, but the US Act does not want all these extension done. So we 3 years exclusivity or 5 years exclusivity actually have regulatory exclusivity. But regulatory, so when you want to get a 5 years new chemical entity exclusivity, you have to submit your application to the US FDA. So these are not directly governed by the Patent Act. What is governed by Patent Act is a PTA and PTE, Patent Term Adjustment, which is for the loss of your examination in a patent office, and a patent term extension, which is a loss of your patent term because FDA was reviewing your dossier. So the PTE is granted by the US FDA. I'm not going through this, but I'll be sharing this presentation with you. It's very extensive. I'll just touch upon the brief part of it. So, grace period in India until June 2020, until March 2024, this grace period was 6 months. Meaning, if you have done some paper publication in some of the international symposium, or you have done some in your MPharm, you have to do dissertation and everything, and you now feel that a patent should be filed on it, then it has to be filed, it was required, it has to be filed within 6 months. We had personally a case where an inventor had published something, and then he filed an application, and it was at the end of 7 months when the patent was filed. And we have to abandon that application because it went out of that window. So its own publication in some journal became a prior art for my patent, and it was exactly the same. There was no argument that I could pick up to convince the examiner that the publication is different. Same composition was recommended. So personally, we had to deal with that composition. Now, with the recent amendment in the Indian Pension Act, rules basically, they have given this to the company, which is good. So, a tip for all of you is when you are doing any presentations, going whether internally or outside, to give a thought that can this be patented? You know, in MPharm, at least during my time, I never gave a thought that whatever research I am doing can that be patented. But I urge you all to give a serious thought, whatever research you are doing, even your MPharm project that you are doing, is there anything which could be patent protected? If yes, file a provisional application to secure a priority and then do any publication you want. There is a pre-grant and post-grant application in India. It's also there in the Europe. Europe call it as a third-party observation before the patent is granted, and once the patent is granted, it's post-grant application. In US, there are multiple ways of doing that. In India, patent review cannot do not have a opportunity to correct its own application. So pre-grant, post-grant is all application. Some third party has to correct. Whereas US allows your inventors to recheck their patent and get it ratified. So they have post-grant reviews, which is for the inventors, and for the opposition we have something called as inter-party reviews, which is IPR, and then you can directly go to district court in the US for the opposition or revocation of the patent. In US, that system really does not happen. Usually, it is IPR which are most prevalent. Nobody will really go to district court and say that this patent should be struck down. They will go with their product, they will be sued, and then the district court litigation will ensue, and the outcome will come whether the patent is valid or not. Whereas in India, it does not happen. You can directly go because the Appellate Board of India is now struck down. Any post-grant oppositions or invocation have to be done with the high courts. You cannot do it in the patent office. Whereas in US and Europe, it is still there. So you can file an IPR with the US patent office. You can file an post-grant opposition with the European patent office, but not in India. All the post-grant opposition has to be filed within a year's time from the date of grant of patent. If you miss that, then you have to go anywhere super court, whether district court or a high court or any other specific IP courts in the jurisdiction to challenge the validity of the patent. So who can apply the patent? It's an easy part. So I've done with the difficult part of the law. Now who can apply the patent? Simple answer, anybody can apply. Okay? But the law doesn't do that. Law says any person claiming to be true and first inventor, his legal heirs, his representatives can only apply the patent. So say for example, you are in the college, you are doing the research and you want to apply for the patent. So you can apply for the patent, but you will get a permission from college. Now tomorrow college may say that since you are applying, it should be on my name. Right? Why my name should be on? I am giving you resources. Right? It should not be a personal, it should be assigned to me. So that is where the assignments come into our picture. Now in college you do not have any contracts. In industry there is a contract. So when you join, you sign a contract. And every contract in any industry will have a clause that says that any IP generated by you during your course of workmanship with the company will be owned by company. So legally I'm not required to take any other assignments. But in patent what we do is we also take an additional assignments with the inventors so that we become their legal representative as per the act. There are set formats by each country on an assignment. So when a college asks you for an assignment, your hands are tied to how to assign. You can't do it. Because by the time you are filing your patents and everything, you are informed still not. So jokes apart, to assign it to college there is no harm. Because you will be an inventor. Assigning it does not give away your chance. If college is able to commercialize it, then you can check with the college that if they are earning any revenue, some benefit could be passed to. In industry, that does not happen. There are incentives program that run. Only through those incentive program, you may get some incentive. Very rarely companies give royalty. Usually Japanese companies are ahead in this particular program that they provide a royalty. So if you are an inventor, you have invented something, they have patented it. Either they have licensed it or they have used your patented invention into their commercial product and they are earning the money, they will pay you a royalty, which is predefined in a contract. But that's the Japanese act. The Japanese common law requires you to do that. I'm not seeing this happening anywhere in any other part of industry. In a kind of that. But I'm not seeing that. Definitely, it's not a practice in India. We may run some incentive program where we say that if you have some inventive concept, please come to us, go to file a patent, and then there will be some incentives. So one-time incentive, one-time work reward. Companies are smart, so if I have to set goals for some other team members, I will ask my boss, why don't you add a goal of you should file at least one patent in a year. So now that I'm doing an incentive part taken, that's a part of your KR. You have to do that. If you don't file a patent, so formulations are very groups, 3, 4, 5. Now my KR is I should be filing for patents. I cannot do that unless formulators come to me. How will I achieve that? I'll ask my FND head to say that, okay, why don't you have a KRA which says that you have 5 groups, so 10 patents should be filed. So each group should file 2 patents. Once it becomes a part of KRA, there is no incentive. The incentive is your appraisals. If you fail in filing the patents, that particular KRA is 0. This is a typical flowchart for the Indian patent system. Overall, it remains the same. It can change from country to country. So, first you file a patent application which is called provisional or complete. The difference in provisional and complete is that provisional application is not published. It is simply filed to protect something called as a priority date, or your date when you first claim your invention. There are no claims mandatorily to be filed with the provisional application. The application is published 18 months from your first filing date, only if it is complete filing. Now, advantage of provisional system for the companies is, I have some concept right now, I am claiming for priority, so I have filled a provisional application. I get 1 year to file a complete application, but I have not reached to a level where I exactly know what claims should be taken. The opportunity is I can file again a provisional application. There is a P-liner that I should not allow anyone to publish any data for this particular application. Because if that is published, then my second provisional application will now have a date which is from that second provision. So anything published before that will be a public provision. Complete application in US, in India and in Europe, you need to file request for examination. In Switzerland, it is deemed that it will be exempt. If you are filing a standalone application in Switzerland. Initial term for filing the request for examination was 48 months from the date of first filing, which could be either provisional filing or complete filing. It is now changed to 31 months from the March. It is always advised that when you are filing a complete application, if you are sure that this is the invention which is going to work when you have an interest, file a request for examination. Because the day you file a request for examination, it is that day the Indian Patent Office will put your application into queue for examination. So you may say that I have filed a patent application today, and with the new law I can file a request for examination in 31 months, so I will file it at 31st month. At that moment, your application will go into queue for examination. So if there is any backlog, it may take up 6 to 1 year for its actual examination to happen. In that case, you probably have lost 3 years of your patent term protection. So, if protection is such that you really are interested in getting a patent, once you file a complete application, immediately file a request for examination so that it is there. Of course, you cannot file it before publication, so you have to wait for 18 months to go. But the minute it is published, you can immediately file a request for examination. It is then examined by examiner. He may have certain objection. He will issue something known as a first examination report in India, non-final action in US, and examination search report in Europe. So these are nothing but the objection raised by examiner on your invention. If you are able to overcome them, then there is a intent for grant, which is published. There is a opposition period, pre-grant goes on, that is not impacted by this in India. Once it is published, your patent is granted. So you will see an official gazette publication that a patent is granted. Patent office will issue the patent certificate. You can claim a protection from the date a patent application is published, but you can enforce it only after it is granted. So when I go to court and say that XYZ pharma company has infringed my patent, I can claim a damages from my initial publication of application, but I can file a suit only after my patent is granted, not before that. So enforceability starts with the publication, but it can be enforced only after the grant of patent. This is how typically a patent will look like. It's a US granted patent. The first page will have a patent number, the priority, assignee, when it is published, and all that stuff. I'll skip through this directly to the last slide because of the time. So I put a slide which some reason is not coming up here. It was an opportunities of job opportunities for the graduates. So basically, just to sum up, you can join any in-house IT team as an expert. You have a technical knowledge, and with the hands-on training, you will start getting the legal knowledge, which is how the act works, how it is to be interpreted. You can also have your own startup. Where you are innovator, but you know what can be patented, what cannot be patented. There are law firms who hire in firms of PhDs, but then you will be required to do a law also along with that, because usually law firm will give you more weightage if you have a law degree. So they simply don't want a technical expert. They want some expert who is technically qualified to argue a matter in court, which is not a mandatory requirement in the industry. Industry is quite okay hiring experts who are technically good. Expert like me, I'm not a lawyer, so I'm still a heading IPT. Another part is nowadays there are some database providers, commercial database providers who provide supports to industry on various aspects. It could be prior art searches and validity searches. It could be something wherein they will want to give you a list of patents of a particular product. Do their due diligence, keep a watch on the market on litigations and everything. So some of the companies like IQVIA, IPD Analytics have started hiring people in India. They were US based, but now they have good presence in India. So that's one opportunity where you are not into main pharma industry or chemical industry, but you are into a support industry which provides support to this main film industry, either in terms of providing some prior art or some technical inputs. Any questions?
Very good morning, sir. Actually, my question is related to the application, basically electric-based type of the innovation, which the government provided just for the 7 years patent for that products, which related to electric. So it is basically that if a normal person can going to apply a patent for this application for the any devices, so it is just for 7 years, and after that it will going to be disclosed and anyone can just adapt it and going to start a business or start it for it. So how we can use and utilize this in very small and limited amount of time?
these are usually called as the utility applications. And the reason they are granted for 7 years is not because, it is basically because of the industry. So the IT industry, the electrical industry, the mobile industry is growing so fast that what you are patenting today, probably in the next 6 months is not really going to be right. So that is where they want to have a limited rights given to you. So that in those 7 years, you will recover for the inventions that you have done. Suppose that it is available for somebody else to adapt it. Now, the users who will adapt this, is going to adapt this, could be someone from a tier 2, tier 3 cities where they really need your invention, but they cannot really afford to have it from you. So after 7 years, they can start their own small set. But in that 7 years, you would have already developed something new in your own field on which you will have to.
My second question is that I have visited a lot of startups. So what I had found that they didn't go in for the patent because lots of money is required. After the patent also they have to give for months. So what is your thought? Like a person should go for the patent or for the trade secret?
See, patent or trade secret depends on the company. We cannot simply give you an answer because even in pharma, there are things which we want to keep it as a trade secret. So I may have a composition patent, but there could be a trade secret on how that composition is prepared. So you may try everything, but there is a key step, a key temperature requirement which I am not required to disclose. I know patent requires me to disclose, I would have disclosed your range, but not that particular specific requirement. So it's not that it is not. I understand startup really have the foundations, but if you see government has come up with a lot of startup initiatives. So the fee is reduced significantly for all of them. They really don't need to hire any patent attorney outsource. If you go to Indian Patent Office site, there is a list of patent agents or trademark agents who are part of this startup program. You can approach to them and all the professional costs is paid by government. So you don't have to pay them any professional costs. So say for example, you come to me as a professional, there is an official government fee and then there is my fee, which is a professional fee. Now that professional fee is significantly higher. Now that is taken care by government. And those who are enrolled into this program cannot charge you anything. If they charge, it's illegal activity and action can be taken against them, right from cancelling the patent engine certificate. Even on the maintenance of fees, there have been discounts. But a startup should have patent trial because that's how your valuation will increase. If you go for any funding rounds, everybody has seen a startup. If you are going to a funding round and if you put them that I have an international patent and I have this much patent portfolio, they are more interested in investing in you. The question line changes. Now they are not doubting your technology because your technology is proven by way of patent. Now they will start asking you more questions on how you are going to expand this rather than talking your technologies. So for startup, protecting their IP is must. Because that's how they will get valuation. If tomorrow you want to sell your startup to any company and you do not have IP, no company will be interested in buying that. However good that particular product could be. See, at the end it's a business, right? So if as a company I want to do a business, I need some protection. And the way it is going to get is through the IP.
Thank you so much, sir.
So, does IP has an impact on pricing or affordability of a product?
Indirectly, yes. But in India, we have Product Price Control Act. So, you can see a lot of patented products are at a higher valuation. But if they are bought into DPCO Act, there is a capping. And of course, if there is an IP on a product, it will get a higher price. That's also one reason where Indian Patent Act has a compulsory licensing for the pharmaceuticals, where the drug is really not available in India because of the distribution issue or the pricing issue, and you are not able to successfully negotiate with the brand to come up with the raw versions of the generic version. Indian government will improve the authorization and you can enter into the market. So many of the anti-cancer drugs initially, Natco Cipla had successfully done this. they went for compulsory licensing and they could reduce the cost.
Thank you, sir.
Thanks for your time. I think there is one more questions I can take.
So my question is that you told that patents are given at territorial level. So what if a company in America uses the same logo or design of a company registered in India? So in that case, are there any international laws or the Indian government?
You are confusing patent with the trademark. So your logo is a trademark.
Yes, sir. Trademark.
Trademark, again, there are international treaties like Madrid Protocol through which you can internationally protect. But yes, they are again territorial. But if your trademark is registered in India and you believe it is a well-known trademark, your product is also available in that particular country, you can file a suit against that particular company in the US who is using a trademark which is same or similar. But they are territorial. Right? So if you do not have any presence there, it will be difficult. But if they come to India, you can always stop them from entering India.
So my second question is that when a company is new, so it does not have much funds to go for trademarks, for logos and name for the company. So in that case, according to you, where should company focus more on, like getting trademarks or growing their business?
Your focus should be growing the business. So like I said, trademarks are not required to be registered. Right? You start using your mark on your service and you expand your business so much that everybody knows this particular mark is associated with you. Once you have the money, go for registration. You can register trademark anytime. Like in my past organization, which is NQ Ethicals, I registered NQ Ethicals trademark, the name and logo, in class 5, which is pharmaceuticals, in 2018, while the company was already 20 years old. So it's not really when you register, but they were using it, right? We were using it on all the drugs that we were manufacturing. So it was easy for me.
Thank you.
Thank you, sir. I now request Dr. Deepak Bharti, HOD and Associate Professor, Department of Pharmacology, to kindly present a certificate of appreciation to Mr. Ajay Sohan. Thank you, sir. We shall now begin with the next technical session on entrepreneurship and challenges. I now request Ms. Shreya Tare, second year M.Pharm, to introduce our next speaker, Dr. Mandar Kodkuri.
Good morning to one and all. Dr. Mandar Kodgule is the chairman and CEO, IQGen X Pharma Private Limited. Sir has completed his B.Pharm from Pune College of Pharmacy, University of Pune, M.Pharm and PhD from Bombay College of Pharmacy, University of Mumbai. Sir has worked as a lecturer in pharmaceutical chemistry for 3 years in Bombay College of Pharmacy. Sir is a certified patent agent and graduator in India. He has completed Oxford's Advanced Management and Leadership Program from Safe Business School, University of Oxford in 2012. Dr. Mandar Kodgule has about 25 years of experience in pharmaceutical industry in the areas of computer-aided drug design, chemical research and tech transfer, intellectual property, business development, corporate strategy and strategic alliances with companies such as Ranbaxy Laboratories Limited, Landmark Pharmaceuticals Limited, Wockhardt Limited and IQGen X Pharma Private Limited. Dr. Mandar Kodgule worked with Minister of Trade and Commerce and Technical Advisor Professor Masarkar on finalization of draft for Indian Patent Act 2005 and its amendments in 2006. Sir has successfully bagged maximum granted patents award by Government of India and Pharmaxil for work for 6 years consecutively and maintained a 100% success record in US litigation. GEPRA's Dr. Radhakrishnan Gold Medal Award for Outstanding Individual Achievement and Distinguished Service in Special Education, that is in Pharmaceuticals, in December 2012. IP Gems of India Award given by Questel Group, France in June 2018 in recognition of services rendered in the field of IP in pharmaceuticals and healthcare. Top Pharma Leaders Award given by Conference Gorilla in June 2009. Most Influential Award in Packaging Industry Award conferred by National Congress and Awards for Sustainable Exports and Packaging in November 2019. 101 Most Fabulous Global Healthcare Leaders Award conferred by Economic Times Now and World Health and Wellness Congress in February 2020. Outstanding Leadership Award conferred by Health 2.0 in recognition of contribution to the healthcare industry in March 2020. Dr. Mandar Kothure is affiliated with various government schemes. Sir is an expert committee member on pharmacy course for Rashtriya Uchchatar Shikshan Abhiyan, that is IUSM Maharashtra State. Sir is a recognized guide for PhD and M.Pharm courses conducted by University of Pune and Rajasthan. He is on advisory board for several universities for syllabus preparation and visiting professor. Sir is invited speaker for conferences conducted by IBQC, IBC Asia, IDMA, UPM, CPHI and various others on pharmaceutical R&D, patent law, Tax-Paxman Act and strategic plan. Member for various governmental and non-governmental trade organizations such as FICCI, CII, Pharmaxil, IPA, IDMA and Continental WHO. Sir has 5 international research publications, 115 patent applications and 22 granted patents. I request Dr. Savita Tauro ma'am to present a bouquet to Mandar Kothure sir. I now request sir to take over the session.
Am I audible? Yes. Okay. So the moment I am not audible, just let me know. Okay. So good morning to everyone, and I must tell you that me and Dr. Savita, we are batchmates with colleagues in M.Pharm. In the same lab we work. I am also medicinal chemist. She is also medicinal chemist. And it was great. I mean, we just were talking about those days. And all of you are really fortunate that you are listening about inventions, you are listening about entrepreneurship and challenges and patent law, wherein we really, even in Bombay College of Pharmacy, we were not really exposed to any of this. I remember one seminar we had on medicinal chemistry, some professor from Boston University had come and delivered. And believe me, in those days, what he said, firstly, the accent we couldn't get. And secondly, what he was talking was completely over the head, even though we were in M.Pharm. Because the amount of information was not available. We used libraries. I don't think any of you has even seen how a library looks inside. Have you seen chemical abstracts? Anybody? Have you seen Journal of Pharmaceutical Sciences? Actual journal? Read it? No. We belong to the era where we had to look at chemical abstracts in order to find research information, research articles. We had to go to IIT, ICT, from Bombay College of Pharmacy, or go to Hafkin Institute, or go all the way to HCL Pune in order to find one particular article. Now you have everything. So what had changed over a period? What had changed over a period is evolution. Things evolve. So what our parents went through when they were doing their education and what now you are going through, what we went through, there is a vast difference. Okay? And therefore there is this change that change is happening very rapidly. Now tell me, how many of you want to become entrepreneur? Raise your hands. 3. Only 3 want to become entrepreneur? 1, 4, 5, probably 5. 5 out of maybe 35, 40 people, 40 students that are here want to become entrepreneur.
Country, whether it is Britain, France, Germany, Denmark, Norway, Finland, everywhere, even from Russia, Poland, all the way to United States, following who? Columbus, in search of a promised land. Right? So Columbus wanted to come to India to explore something. Unfortunately, he thought the world is round, so he went the other way, landed up somewhere, thought it is India. It was unfortunately Cuba. Okay. But then Amerigo went to America, start exploring. Oh, there is a huge land, promised land. Okay. And all of them went there to explore opportunities. They had struggled. They had to fight with the native population. They had to fight amongst each other in order to make money. That's why they became opportunistic. They went ahead and started exploring new areas, started creating farms, started extracting minerals, started extracting oil, started extracting and getting into interiors of United States, and they became entrepreneurs. They made money. The money that they made was invested in the same land. And look at where they are right now. In 400 years of their history, they are the top economy right now. Right? Same thing happened in Europe. In fact, if you look at what happened in Europe, is new innovations came in. Steam engine, remade, Marconi discovering radio, somebody discovering atoms, somebody discovering chemistry. Everything happened in Europe during that 1500 to 1700 period. And everybody started exploring, and they wanted that to remain as their own right. So they created patents. They started selling their products, started making money, reinvesting on their research. That's how we are seeing all those big companies which are there, Pfizer's or GE and all other companies, big multinational corporates. They are not started 40, 50 years ago, they are 100 years old companies. Okay, so that's how we are different from the Westerners, and we don't think entrepreneurship. Only 1% of our population, entire population, becomes entrepreneur. The other thought in the mind is, why Adani and Ambani are making so much money? Right? That communist thought is also there in our mind. Only Adani and Ambani को ही सब मिलता है, टाटा को ही एयर इंडिया बिक गया, If you have the capability to run that company, such a big operation, try. It's not easy to extract oil and natural gas and sell across India. It's not easy to create a 5G network in such a torrid country like India. Go to Nepal and see what are the problems. What are you having over there, and put one Adani over there and he'll change the country completely. Right? So you need entrepreneurs. You need, in order to grow your economy, you need businesses to grow. That's what happened in US and Europe. Now what is entrepreneurship that we are talking about? Okay? It is doing earning revenue through some activity which we call it as a business, okay, which is run by you, right? So we are either employees or entrepreneurs. Two columns. What is leadership? You are leading a team, right? So forget about the qualities. You are leading a team. What is the difference between leadership and entrepreneurship?
Leading a community where innovation or the ideas.
Yeah, so you are leading multiple teams. Okay? You are leading multiple teams in entrepreneurship. Whereas in leadership, you may be running multiple teams, or you may be running one single team, or you may not have been asked to run a single team, but you are still a leader. Okay? Uddhav Thackeray, leader, right? I mean, pun intended. Don't take it seriously. But there are a lot of leaders, right? Nobody believes them in their leadership. Maybe few people, but they are leaders. Okay, so, and some leaders like, Sudha Murthy, they never got that leadership. They never demanded those positions. It was given to them because they demonstrated leadership. Right? The struggle Dhirubhai Ambani must have gone through in order to create the Reliance Empire. Can you imagine? Coming from a very small village in Gujarat, having nothing virtually, and now becoming this. It's very easy to blame them for earning money, right? With all the so-called intellectual mindset. But we are really not looking at the effort any person is taking in order to become an entrepreneur. And believe me, not every entrepreneur is a successful entrepreneur. Right? So, why person wants to become an entrepreneur? Do you have any idea? Anybody has any idea? What? Okay, somebody raised an idea.
Because that person is faced these social issues that didn't want it to face by the society again and again. So for that they are the one who are going to fight for it. This is my thought.
Okay, good thought. So you are not fighting for the same cause, you just want to start something on your own so that you are fighting for some cause which nobody other is fighting.
Yes.
Okay, good example. I think somewhere down the line, if you see how Luton started their journey, they put tuberculosis as their primary target and started developing the country. Okay, how Wokhard started the journey of NC is because they identified that nobody is working on MRSA. How Biocon started working on peptides and proteins is because they said that nobody is doing this work in India, let me do something. right? So it's a unmet need. Somebody explored an unmet need and thought that if nobody is looking into that, let me start doing it. Any other reason that you find? The one biggest reason I must tell you is the craziness. So entrepreneurs are crazy. Okay. When you are earning a decent salary of around 1.5 crore, 2 crores a year, okay, having a wonderful position in the company, everything said, you have stock options, you have everything, you have a team of about 100 associates working under you, boss, बहुत अच्छा सब कुछ घर है सब है. Why somebody starts an entrepreneurship? Invests whatever he has learned so far, he or she has learned so far. In a business, okay, hire people, create the same setup what you were working earlier and try to aspire to be the same company that you work for. Well, you are already there. And in this whole process, probably 10, 12 years, you are not going to learn anything. You are not even going to, you might get a salary which is 1/10 of what you are drawing from a company where you are working. Craziness, pagalpana. But that is called as passion, that is called as dream, that is called as vision, that is called as objective, that is called as your enthusiasm to do something different. Right? You dream something, you want to do something passionately, and because you are working in a set industry with set rules, and as Anjali was saying, set KRAs, करना ही है ये, इन्वेंट करो, नीति करो, पानी में डालो, एक ईयर एंड में गाजर दिख रहा है टंगा हुआ जिसको कहते हैं अप्रेजल, राइट? सो एवरीबॉडी इज लुकिंग एट दैट गाजर एंड थिंकिंग, ठीक है यार, एक साल के बाद तो कुछ तो मिल रहा है ना, करते हैं, क्यों पैसा खराब करना, व्हाई आई एम स्टार्टिंग माय ओन बिजनेस अननेसेसरी, सेट है, राइट? And this is the Indian mindset. My life is set. I must earn. Earlier, those who are of our age, definitely Dr. Savita would agree that our parents wanted to become government servants. Okay? Why? Safe job. Pension है, सब है. Everything, provident fund, pension, 5th commission, 6th commission, 7th commission, lifestyle. Okay, our generation, job. Okay, the next generation, I'm still seeing jobs. I'm still not seeing startups. I'm still not seeing entrepreneurs coming. It's jobs. So have we really evolved? Have we really moved away from our own incompetencies, our own, what you can say, shelters? Why are we afraid to explore something? Yeah. All of you are not more than 22, 23. एक साल अगर यहाँ वहाँ हुआ है, it's okay, no problem. But you're 22, 23, max 25. What are you afraid of? If you do something, okay. Anyways, if you're getting a job in any company, okay, tell me frankly, how many people advise you to have a better job. You will get a better job than this. How many people will tell you? Almost everybody. Okay? Why? And you will do that. You will do the same thing if somebody comes and tells you that I am getting this job, what should I do? So then, दूसरा देता है उधर शायद 15,000 में काम करेगा. You are not looking at experience, you are not looking at who is his boss, what he is going to learn, how he is going to explore, use this as a ladder to go to the next position. Nobody is looking at that. Everybody is looking at that number, Udajar. And that's our problem. We are not here to take experience. We are not here to learn anything. We are just here learning all this 4 years and 2 years of M.Com for what? Salary. Kitna salary milega is the eventual objective. Okay, so for us, when I got my job, first job, fortunately, I was interviewed by managing director, Innotech Pharma, Dr. Tanuj Doctor, and he asked me, what are you right now? I said, I am a lecturer in Bombay College of Pharmacy. So he said, how much you are earning? I said, my take-home salary is 7,700. So he calculated something in his mind and he said, okay, I will try to give you 10,000 in your hand. In hand. So after, there are taxes and PFs and other things. So my salary was 1.6 lakhs, which was huge that time. Huge, really huge. Those years, I'm talking about 1996. It was a good salary. And many people at that point in time told me, if a small company, emerging company like Innotech can give you 1.6, what do you think Sandoz can give you? ज़्यादा देगा यार, क्या बात कर रहा है? क्यों पाँव पे कुल्हाड़ी? ये कुल्हाड़ी पे पाँव मार रहा है. नया कंपनी है, you don't know what will happen. You set up completely. It's a startup. I said, अभी तो मिल रहा है ना, देखते बाद में. And that was one of the best decisions I made. Why? Because it was a perfect zoo for chemical industry or API business. You name any equipment or instrument which is currently even considered as a model for chemical synthesis was there in Innotech in 1996. I was reporting to the managing director, so I came to know a lot of strategies, objective visions, and he used to call the senior people, and believe me, I was just PhD with 3 years of lecturership experience, that too during M.Com and PhD. No experience. To sit with managing director, to sit with the vice president of operations, to sit with vice president of finance, safety and environment, and learn something about how the business is happening. It was huge, and I didn't realize that for 6 months we were not being paid because the company ran out of cash flow. There was no cash flow, so I haven't got paid for 6 months. But the learning was so much. I continued for 1.5 years more in that company. And that experience became cornerstone for my career later on. Because I could get into Wockhardt as an assistant manager with just 2 years of experience, wherein other assistant managers in Wockhardt at least had 7, 8 years of experience. So salary, all these things. And when I was leaving Innotech, Dr. Tanuj Doctor took an exit, so IPCA took over control, and Mr. Premchand Godha, IPCA chairman, called me when I was, about to leave, and he said, "क्यों जा रहा है डॉक्टर?" And he was very senior person, and I was what, 25, 26. So he got me, "क्यों जा रहा है डॉक्टर?" So I said, "Sir, बुखार नहीं मिल रहा." And he told me, "क्या करेगा बुखार में? वही जॉब करेगा, वही पैसा कमाएगा, वही पीठ थपथपा लेगा, वही ऑपरेशन लेगा, वही करेगा ना। Instead, I am giving you 2 crores. Start your own lab of API synthesis. I will give you 4 projects." But वही typical Indian middle class mindset of mind हट गई। And I said, "Sir, thank you very much. I love chemistry. I will do the job." Okay. Continued jobs after jobs after jobs after jobs after jobs. Continued jobs for almost 25 years. And then realized that had I taken that opportunity 20 years back or 23 years back, I would have been a much better person, much better financially, much better in terms of, creating the talent that I wanted to create, creating what kind of society I wanted to create. Would have got a lot of spare time by now. Because it is my mind, right? What are my vision, what is my dream, how I want to achieve it, and how I am using the resources that are available to me to create that. An idea is, any idea, okay, is not good or bad. The planning can be bad. And worst, execution can be worst of that. How you are going to. So if you have an idea about doing something new, okay, my son, I have a son, he was 11 years old, okay, and I used to take him every time haircut ke liye, I used to take him to a salon, and he used to get frustrated sitting over there, okay, going all the way to salon, spending half an hour, again coming home, taking a bath, and he used to be afraid of those scissors also when he was kid. So he was like 10, 11 years old, and that time he said, "Baba, can we have, just like how we, tell somebody to come for massage or something like that, can we call somebody and he can come to cut hair at her?" I said, "Something like that happens, okay." And then 10 years down the line, this app came into picture. Okay. So you can call them, they come home. You don't have to go all the way to a salon. They give you bath also over there itself. Okay. So everything is available. But that was a thought sometime back in 2011. The app came in 2016, 5 years later. Great idea, right? This .coms, all these ideas, these are great. First idea is great, second idea is great, third idea is great, fourth idea is great. Now there are how many online service providers like this? 20. How many online food providers services? Huge, and everybody is making money. Right? It's a small idea. Execution, proper planning, proper everything. Right? You must have heard Thyrocare. Okay? Velumani. What he did? Just started collecting blood samples and delivering it to the labs. That's it. So you don't have to travel to the lab, path lab, in order to give samples. Collecting, delivering, collecting, delivering. He started his business with 500 rupees. Just he sold his entire business about a year and a half back. So you know how much? Guess, any guess? 15,000 crore. How much? जोर से बोलो यार, बड़ा नंबर है, अच्छा लगता है ना? So that's the value of your idea. Thyrocare employed about 9,000 people to collect the blood samples. Collectively, over 20 years, all of them made how much you know? 250 crores. All of them in salary. So who is wise? Value money or employees? So what do you want to be, employee or employer? Think about it. If you have an idea, and normally what happens is, in industry, I mean, Anjali is also, here he is from IP. I also was heading IP. So we gave all these ideas to, formulators and chemical research and state load. State load and chairmen. All those state load. उनको भी हमने आइडियाज दिए, सर ऐसा करते हैं, this is great paragraph 4, this is non-infringement, इसको ऐसा करके भारत को opportunity, ये वो this business, that business, this market, ये product, less competition, all these things, and say great, okay, एक साल के एंड में एक आउटस्टैंडिंग अवार्ड चिपका दिया, एक ट्रॉफी दे दिया, कुछ 10, 15, 20%. I'm giving you 20% increment. Happy? Happy, sir. 20%. Wow. So, and how much save made? 80 million on Metoprolol. One single product. Okay, I have the patent on my name, unfortunately. But he is making money. Right? So, my whole point over here is, it is not easy, it is not easy to become an entrepreneur. It is not easy to think through like an entrepreneur. It is not easy to generate the kind of initial capital that you require. It is not easy to make a plan what you are going to do. Are you going to get into a business which is capital intensive, or you are going to get into a business which is less capital intensive, which is service, goods, sale, commercial, what you want to do. But if you have an idea, think through that idea, discuss with experts. I can give you, this year, I think Government of Maharashtra had that Avishkar week, right? Avishkar year. So wherein,
State innovation.
yeah, state innovation. So I was in Nasik, looking at all those, some students had presented over there. Something like we evaluated 150 posters and posters we evaluated, and we took out 6 from that to go to the national level. So those 150 were really brilliant ideas. Okay, brilliant ideas. Most of them, at least 30-40% of them worked on extracts, plant extracts, for some kind of anti-infective, anti-parasitic, mosquito repellent, painkiller, anti-fever, anti-diabetic, all these activities. Okay? And I asked them one question. It's a plant, right? Living thing. It wants some protection against inflammation. It wants some protection against parasites. It wants some protection against excess sugar to be produced inside the plant because it's not in its physiology that, right? So when you are extracting something out of plant, it will have all these properties. What's the big thing here that you are doing? The big thing is identifying the actual ingredient which is causing that. Enrich it, isolate it, characterize it, and then use it rather than using the extract, which contains half a dozen unwanted things. Right? So how you are defining your thought process is very critical when you are looking at inventions and further you are looking into entrepreneurship. You are not selling garbage. You are selling something which is really makes sense. It's an unmet need, maybe. Okay, somebody came up with a wonderful device which was like blood clotting, instant blood clotters. So if any injury is happening or anything which is happening to a soldier, trauma injury or deep cut wounds, then how the blood flow can be stopped, and it stops immediately within 1 minute or 1.5 minutes. She was maybe final year B.Pharm student. She worked on this. She got it patented. She filed for a design patent. She filed for that trademark. She got initial 2 lakhs investment coming from a VC or a venture capitalist to get into a prototype phase. Right? And that lifesaver thing only costs about 50 rupees. Imagine the impact on the army and military globally with that kind of small bandage. 1.5 minute, any injury, stopping the blood flow. And it is not great. She was just using resins, absorbent cotton, cement, something like that. Very basic things. DRDO, I invested in this thing. I immediately gave another lakh of rupees. I said, once you have a proof of concept, I will help you do further studies, and we are doing those studies. But DRDO already signed and gave us 2 crores as a non-exclusive license. 2 crores. So far, she has invested, that girl has not invested more than 5.5 lakhs in this. So you can imagine, very small investment, big, great returns that she is getting, and this is in pharma, still pharma or healthcare. Very simple things, 1mg or Apollo online. This is a concept, right? Can you further improve the concept? Now there is another concept which is happening at a pharmacist level in US and Europe, wherein we have just get the validation of that system, wherein it will automatically pack the tablet, generic tablet. So you are not going to take it in a bottle or a pistol predetermined. Okay? The manufacturer doesn't have to provide that to the pharmacist. He just has to provide the bulk. And from that bulk, the moment pharmacist punches, based on the code of that, The tablet will be dispensed, it will be filled in a bottle automatically without any hand touching it, or it will be blistered without any control on that. No manpower required. You can imagine how much amount of transportation cost this is going to save, how much amount of ease this is going to create. And this small concept, when we ran it through Walgreens is currently evaluating this at $2 billion. $2 billion just for automatic dispensing of tablets and capsules. What are the challenges in that? Each tablet has a different dimension. So how you are going to put that? How you are going to store? What is the mechanism? Are you going to use the weight mechanism or the count mechanism in order to fill? So there are a lot of things that go on inside, but once you have mapped everything, it becomes very easy. So what we did in that process is we analyzed close to about 1 lakh different tablets for their dimensions in terms of size, length, width, breadth, ratio. And we tried to create a commonality for all these things, that if the length is, let us say, 6 millimeters, then what should be the width and what should be the thickness. So we formalized that as a part of algorithm and we gave them some equations. So we just gave them equations to the innovator and it gave us almost about 60 lakhs of rupees just to generate equations. We charged them 60 lakhs and we still hold about 0.1, 0.2% of equity in that company. 2 billion, 0.2% is also bother. Okay, so think, when you are thinking in terms of ideas, these are ideas. You have resources, you have experts to run those ideas. Government is ready to help you in terms of funding. Okay, if your civil score is good, if you have not defaulted anything, even if you are starting a new something, okay, when your credit score is not there, but you have a decent enough good story to tell, decent enough good profitability to be over 3 years or 4 years, government is giving 2 crores without any collateral at a very cheap interest rate of around 11%. If you have any collateral to be put, it still goes down to about 8.5%, 9% interest rate. Exploit them. Think of doing something and you will find like-minded people investing in you, contributing into your thought process and ideas. So though there are challenges, I suggest every one of you don't take entrepreneurship as big challenge. It is a big challenge. You don't understand the finances. As a pharmacist, we really don't know finance at all. We don't know a lot of things like cash flow. We don't understand accounts. And it is my recommendation to you that please start learning these terms. Start learning working capital. Start learning inventory. Start learning capital, CapEx. Start learning about how you will manage the cash flow. What is cash flow, first of all? Debtors, creditors, all these. And once you understand all this, the business becomes really very easy. And believe me, there are a lot of like-minded people in the market whom you can use as your resources, as your fallback options. They will help you because they have the same dream like you. And even if you fail, okay, in first 2-3 years, you will realize that this is going nowhere. Okay, No harm in it. Because you are not yet cross 30. You still have another 25, 30 years of your life, full working life available to you. You can make a lot of money. So money, don't keep money as an objective. Keep doing something really good, what you want to do. Learn, experience, get that experience, get that different flavor. Right? Any questions?
So, what your suggestion for our young generation regarding this topic? Like, as a person in the future, they should first go for the startup companies and working there and get learns new things, or they should go for the MBA.
Unfortunately, there is no one solution that fits all. Okay, what my suggestion is, if you have an idea, if you have a really good idea, don't leave it there. Explore. If you don't have an idea, get the experience by working somewhere. And over there, when you're working, don't think how much I'm getting in terms of money. Money, I can tell you, is secondary thing. And you will get a lot of money. There is absolutely no difference, I can tell you from my own experience, is that there is no difference between a 5 lakhs per month salary and 3 lakhs per month salary. There is no difference at all. Because most of it goes into taxations. Okay? Below 3 lakhs, you are exempted. 5 lakhs ke above, you are paying, right, tax. So it works out to be the same thing. सिर्फ क्या फर्क पड़ेगा? 5-6 हजार रुपया महीने का ज़्यादा. But in that case, if you are going to a company, okay, where like you there are 90 or 100 people, where are you going to get any kind of learning? Why I am advocating you to go into a startup or smaller companies is because that's where you will learn the entire ecosystem. If you join any formulation department, okay, with a company like Dr. Reddy's, 700 scientists are working there. Who is going to notice you? What work you will be doing over there? Nothing. But if you join a small company, wherein in that entire company there are 30 formulators, chances that you will get at least one project independently in 2 years is great. You will understand what is happening on my product actually in dissolution, because you will be able to get into analytical department and see the dissolution happening in front of you. Right? You will be able to see how my tablet looks like in stability. Because in bigger organizations, you are not allowed to go there. Islands है. Formulation in one island. एक संस्थान, बड़ोड़ा संस्थान, Sayaji Rao, Raja, Udarga. Then another संस्थान, our analytical, Wajid Ali Shah. Wajid Ali Shah and Sayaji Rao are not talking with each other. Okay? If at all they are talking with each other, they are saying that their product खराब है, and he is saying there are 2 analysis करने का. Right? In a smaller organization, there is no Wajid Ali Shah first of all, there is no Sayaji Rao. And because there is no something like this, these guys are saying, analytical person is saying, look, when I was looking at your product, it showed a little bit, in disintegration, I could see that it is not disintegrating properly. 5 minutes के बाद proper disintegration. Tablet disintegrates, but not before 5 minutes. Innovator का 5 मिनट के पहले, दूसरे मिनट में चालू होता है, कुछ तो polymer का गड़बड़ है. You have compressed it hard or something like that, or use a super disintegrator. Bada super disintegrator. That way, these guys talk with each other to resolve the issue. In bigger organizations, they complicate the issue unnecessarily. Because everybody has a KRA, right? Anjali both say. So अंजलि तो KRA है कि उसको 10 एप्लीकेशंस फाइल करना है, यही जबरदस्ती कर रहा है सब लोगों के ऊपर, फॉर्मुलेशन वालों को कि तुम 5 तो करो ही करो, तुम करो भाई, तुम्हारा KRA है, तुम 10 करो, right? So this is the way industry works. So if you want to get some experience, if you want to learn something, if you want to get into some kind of a limelight and see the whole cycle of a product, many people I have seen come into the formulation department. एक साल काम किया, प्रोडक्ट प्रोटोटाइप डेवलप किया, दे दी, आगे अभी तो फॉर्मुलेशन कुछ नहीं है. I know formulation. They go into another industry because 50,000 राइस मिल गया कहीं, गॉन दे, वहाँ भी वापस क्रैच से चालू डेवलपमेंट, वहाँ भी तीसरा कंपनी 2 साल में स्केल अप किया ही नहीं अभी तक. वो लैब का टेक्नोलॉजी स्केल अप भी क्या होता है मालूम नहीं. So when you are moving from a 15-inch pan to a 36-inch pan, when you are moving from a 10-liter blender to a 500-liter blender, what is happening you don't know. Nobody knows. Scale up factors पता नहीं, how to write PDR कैसा लिखना है पता नहीं, product development report. You don't know how you are going to commercialize the product or exhibit batches में क्या problem होने वाला है पता नहीं, query answer. So when you file the dossier ANDA, regulators are going to raise queries. You don't know how to answer the queries. 6 years into the industry, you are not seeing a full cycle of one single product in any single industry. You are lost. You have just became assistant manager formulation with no experience of formulation at all, because you have not seen a full cycle of the product. Same thing applies for chemical research, same thing applies for analytical. You should do the validation of your developed methods. Then you should look at all these, commercial, analytical, tech transfers, commercial support, changes in the monograph, defending the queries, stability protocols, all these things, unless you understand that. Secondly, what many people believe that, good jobs. What a good job? Project management, regulatory, IP, quality, QA, okay. Table jobs है that. लैपटॉप डेस्कटॉप मिलेगा, आराम से करो, कहीं लैब में जाने की जरूरत नहीं है. Okay. Problem is, if you go get into these jobs, believe me, you will not be successful at all. थोड़ा लैब में एक्सपीरियंस चाहिए, whether formulation, analytical, QC, manufacturing, कहीं ना कहीं तो लैब में एक्सपीरियंस चाहिए, because then you know what happens to the product and you add value, start adding value into your regulatory, into your IP. And I worked for 8 years in chemical industry, chemical synthetic, before becoming an IT person. So बाद में कोई साइंटिस्ट मुझे आके बोल नहीं सकता था, ये क्या बात कर रहे हो सर, ये ऐसे नॉर्मल इन्फ्यूजिंग होता है क्या, ऐसे नहीं होता. And I have seen a lot of IT people who come into the industry start suggesting formulation people. For example, we won the case on cefuroxime, acetyl and ranbaxy because we had a 10% के नीचे हमने amorphous रखा, more than 10% amorphous रखा. The patent was on amorphous cefuroxime acetyl. We kept crystalline, so we kept amorphous with 10% crystalline, and we won the case. Cefuroxime acetyl, polymorph, amorphous versus crystalline. Then came atorvastatin. Okay, atorvastatin, medicinal chemist, US litigations, के लिए atorvastatin identify होगा. Now this is atorvastatin is RRR enantiomer, and that was the patent. Okay. So that medicinal chemist who joined as a attorney in our US office suggested, why not add RRS as an impurity and make it substantially not pure atorvastatin. Okay. Not realizing polymorphs basically same chemistry. They are chemically they are not different. But RRR and RRS are completely different chemically. They may have complete different pharmacological activity also. It's an impurity. You are asking to put impurity in order to make a non-infringing product. ऐसे तो मैंने कहा एसिटालोप्राम में सिटालोप्राम डालूंगा मैं. Substantially pure एसिटालोप्राम क्यों? सिटालोप्राम तो ड्रग है. It's a drug. I'm not adding impurity. Esomeprazole में omeprazole डालो, esopicolone में esopicolone डालो. You know, so there are a lot of things, but at least if you work on bench, you will not suggest some ideas like this, and you will not also entertain. So you will get a good, respect, command even from your colleagues in the formulation. They will listen to you.
Sir, I have one question. Sir, you explained how important planning and execution is for a startup. And I believe go-to-market strategies are very important for the venture before starting the venture. So can you explain how, as a student, we can emphasize or furnish ourselves in that prospects to be market ready or to be startup ready?
What is happening now is, we are not really taking advantage of, there are a lot of consultants around who manage all this. You don't have to do anything on your own. Okay, there are Accentures, there are smaller Accentures. If you go to Accenture, they might charge you something more, but there are smaller consultants also who are specialized into a specific area. They will provide you all these market research and data and everything. And some of it, what you need to do basically is validate that data. So, trust is there, but validate. Because a lot of consultants give you a plan based on their own biases or the kind of infrastructure they want to create. So, for example, when we were trying to get into our own manufacturing, one of the consultants which we were using suggested a specific company for acquisition. Now we did the entire due diligence on that. We found it okay, but later on we realized that it was a single Denmark only approval was there. All the equipments are from Europe. All. Everything, right from blender to compression machine to coder, everything we go from. We started wondering about this company. That these guys are representing or telling us to avoid. So it so happened that the consultant was a brother-in-law of Hugo. This company was getting closed. In the closure, Hugo Farm was only getting 1/10 of the value of the machines. If the company would have got acquired, they would have got the full value. That was the way. So we verified, right? We didn't trusted their data, we verified, and we asked Hugo Farm to take the machines. We don't want machines. We didn't say no. We said we don't want these machines. You take the machine, we will have new machines because ACG is our partner. associated capsules. So we will take machines from ECG. So verify, use experts and verify. So thank you. I think if at all you have any questions, my number is there with Dr. Bharti, Dr. Savita. Please feel free to write to me, call me, and I'll be happy to answer your questions. Thank you.
Thank you, sir, for the informative session. I request Dr. Deepak Bharti, HOD and Associate Professor, Department of Pharmacology, to kindly present a certificate of appreciation to Dr. Mandar Kodgode. We shall now begin with the next technical session on entrepreneurship skills. I request Dr. Savita Tauro to present a floral bouquet to our Honorable Chairman, Mr. Albert W. D'Souza. Thank you, sir. Thank you, ma'am. I now request Ms. Shweta Marade, second year MPharm, to introduce our speaker, Mr. Albert W. D'Souza.
Thank you, Shreyas. Mr. Albert Wilfred D'Souza is the chairman of Adair Education Trust, which has established various Christian religious minority, technical and professional educational institutes at St. John Technical Campus, Palghar, Maharashtra, offering education right from school in engineering, pharmacy, hotel management, arts, commerce, science, and MBA courses. Sir is a visionary philanthropist and renowned industrialist. He is the chairman of Printania Offset Private Limited, a leading print house in India, and managing director of Printania Group of Industries. He is also the chairman of Model Corporate Bank Limited, the vice chairman of Christian Chamber of Commerce and Industry, member of Catholic Council of India. Sir is on advisory board of higher and technical education for Archdiocese Board of Education, Mumbai, Diocese of Mangalore and Diocese of Jabalpur. He is the past president of Lions Club of Bhimanagar, Mumbai. Sir is also an executive committee and governing board member of several minority engineering colleges, management institutes, humanities colleges all over India. Institutions in Mumbai like St. Francis Institute of Technology, Don Bosco Institute of Technology, Xavier Institute of Engineering, St. Francis Institute of Management and Research, Xavier Institute of Management and Research, and Don Bosco Degree College, St. Aloysius Institute of Technology in Jabalpur, St. Joseph Engineering College, St. Aloysius College, and St. Agnes College in Mangalore. He is also on the advisory board of various hospitals and nursing colleges in Mumbai, like Karuna Hospital, Holy Family Hospital, and College of Nursing and Holy Spirit Hospital, and College of Nursing. Sir has many awards to his credit. He has been felicitated with Rachna Foundation Entrepreneur of the Year Award in 2003, Kapal Award for Training Entrepreneurship in 2004, and also being a recipient of Catholic Entrepreneur of Karnataka State Award in 2007, Dimensions Entrepreneur of the Year Award in 2012, and Chhatrapati Shivaji Maharaj Achievers Award in 2019. We welcome you, sir, and request you to take over the session.
Good afternoon. Principal of our Pharmacy College, Dr. Savita Tharu. Today's keynote speakers for this workshop, Mr. Soni from Indoco Remedies Limited and Mr. Mundar Kunduli from the industry. My dear faculty members and my dear students, I am here to give a talk on entrepreneurship. The way I did entrepreneurship without knowing what is entrepreneurship. Entrepreneurship word is very common everywhere. But if you ask to spell the word, people get confused. Am I right? How many can you spell the word correctly? Raise your hand. I'll check. Spell check. Raise the hand. Raise the hand. Those who can spell correctly. Only 3-4 hands are going up. Hand raising is straight. 4. Other people do not know to spell the word. So forget about entrepreneurship. If you ask the right diction of word, how to pronounce, that is also very complicated. How many can pronounce the word correctly? Raise your hand. Only one hand is going up. 2, 3, 4, 5. Just pronounce the word. Huh? Entrepreneurship or entrepreneurship. Okay. You to the mind.
Entrepreneurship.
Entrepreneurship. How do you spell?
Entrepreneurship.
Spell the word. Spell the word.
ENTREPRENEURSHIP.
Okay. Anybody else want to pronounce the word? Anyone else? Better than her. Better diction. Why I am saying this word is very confusing. Very confusing, reality. If you spell correctly today, once again when you write, you get confused. Reality. And if you ask to pronounce the word, they are also confusing. You hear different people, different forums, different dictions. Sometimes you confuse. But this word I am told not from English. Origin of the word. Which language? Latin, Greek. Find out. It's not an English word at all. When I was small, at my age of 21, there was a word called enterprising. We call those enterprising person, very good enterprising company. And company name used to be L&T Enterprises, XYZ Enterprises. Used to go to Fort Pilava, that area, where all the offices were there. These enterprises was very common when we were youngster, when I was young. But entrepreneurship word was not there at all. But today, this enterprising word has gone. It is there in the dictionary. Usage, it is not there. There it has taken over by entrepreneurship, entrepreneur. Go to the bank, being banners. Go any exhibition, go any colleges, management institution, entrepreneurship skill, everywhere people are talking. But in simple, this word belongs to India. This is what BHU professors are claiming. When we said, I was in Varanasi last Sunday, Monday, very close to me, I could just go. BHU is where pharmacy originated from. First institute of pharmacy in India started in BHU Pharma Division. It is still existing. Still existing. I have visited umpteen number of times. They claim, or even IIT professors claim, this word is Indian because the root of this word is in Sanskrit. Sanskrit language. In Sanskrit, there is something called Antarprerana. Write it down, write it down, write it down. Antarprerana is the root or origin from where entrepreneurship word has expanded. You know the meaning of word entrepreneur? Yeah, just say, stand up and say, all of you. What is the meaning of entrepreneur? Antar. Internal, antar. Prerna. Motivation. So, word entrepreneurship or enterprising means internal drive, internal zeal, internal push, internal calling, internal continuous effort without somebody else telling you should have within you. If you have this, you can be an entrepreneur, beginner. Is clear? Clear? Antarprerana you should have and expand over it and see whether you have the roots of liking for another person. Okay? All of us we have, provided you take my route. I tell you my route, how I become an entrepreneur. Okay? First thing required in an entrepreneur is subject knowledge, technical knowledge of the field. Write it down, make a note. First thing required or attributes of the entrepreneur, he or she should have the subject knowledge, domain knowledge, to people knowledge I will call it. Just bit of the knowledge is not good enough. You want to study, you do B.Pharm, M.Pharm, that knowledge is not good enough. That is the theoretical knowledge in the laboratory where they are teaching. But you got to have a subject knowledge, and I call it dimensional knowledge. Dimensional knowledge. Of any field, you can become entrepreneur in any subject. Manufacturing, any topic, trading, marketing, provided you know the dimensional knowledge of the activity inside out. Inside out. Okay? The day you realize you have prerna in you, you think that this subject knowledge I have, not only what you are learning, some associated with it later on, you can think of starting entrepreneurship. Is clear? Now, it is not possible because you are a student, age of 20, 21, 23, you are now maybe 23. Is it mature age? Is it a mature age? Yes or no? Yes or no? Mature age to start entrepreneurship? Yes or no? Huh? Why no? Stand up, stand. Give the mic. My question answer will do immediately. I can expand on that. Mine is a practical lecture. Someone hold the mic here in front. Yeah. Why no?
Because we don't have still field knowledge and experience.
Knowledge and experience. The word experience that matters. Your earlier speaker said experience. Okay. If yes, why? At the age of 23, you can start the entrepreneurship. You have a zeal. I want to start.
I think yes, it is possible if some person have the passion to learn new things at a small age.
No, you are ready to start the entrepreneurship. My question is very clear.
Yeah, we can do, but if we have the passion.
No, that's not theory. I will tell you after study start entrepreneurship. Passion everybody has.
Sir, but lots of people have done the research at small level and started with that is also come with the passion there.
Okay.
And they had converted into big businesses.
Good. Anybody else? If yes, why? If no, why? Starting after your study, immediately entrepreneurship. Question is very specific. Complete F1, no PhD, start entrepreneurship. Yeah, one hand is going up. Stand up and sit.
Good afternoon, sir. If you have some sort of innovative idea and anything revolutionizing through which you can change the world, which has not been taken place earlier in this world, then definitely at any age it is possible to become an entrepreneur.
Possible word is there, no, in your answer. Possible, is it possible? You have to try, no?
Sir,
Possible or impossible, you have to try it out.
sir, in many field it has been seen that if you have skill or if you have experience also, then also it is not sure that one can completely become entrepreneur. So there is also a probability, there is also a possibility. So we cannot completely say that if you have skill along with the knowledge, you will become entrepreneur at any age. Either you have experience, either you don't have experience.
Okay, good. Yeah, one more hand, right side.
So as after B pharmacy, we will not having the inside out of the knowledge about any product or anything. So we should have some type of experience or we can say a knowledge about how a product goes from manufacturing to the market.
Right. Experience. All coming down to experience. Yeah, one more.
So my answer would be no, we can't start because first to build that business, we should first live in that environment. We have to live in that environment.
This is the right answer. However bright you are, however, whatever the deeper knowledge you gain, that knowledge is not enough to start into entrepreneurship. Along with the subject knowledge, I said deeper, wider, dimensional, what you require is experience. This experience you will get, but joining the industry and learning, but back of your mind, you must think while servicing. I want to start one day entrepreneurship. I want to start some activity of mine in my subject knowledge field. Is it clear?